Where is the battle between the Modi government and the judiciary headed, and what is its endgame? I'm Barkha Dutt, you're with the Mojo story. Our focus today is on the Vice President Jagdeep Dhankhar, who has struck again. His newest attack on the court talks about the supremacy of parliament. In fact, he made a specific reference to the NJAC, the legislation that concerned judicial appointments that was struck down by the Supreme Court as unconstitutional and void in 2015. Is the government moving to bring in a new law like that? So far, the law minister has said no. But if that's the case, what is behind these battles? Remember, in the last few hours, the Supreme Court collegium has also written to the law ministry saying that once the collegium reiterates its choice of judge for a second time, the government is bound by that decision. What is this fight all about? Is it about the collegium system? Are we moving towards a new way, possibly, of appointing judges? Is that what's behind the government's thinking? Or is this only saber rattling? And the collegium debate itself, is there some merit in challenging it? What about the fact that the vice president has in fact challenged what has come to be known as the basic structure doctrine, referring to a 1973 landmark verdict in which the Supreme Court declared that the parliament can do anything to legislate, but it cannot change the basic structure of the constitution. The vice president says that was not a parliamentary decision, it was a court verdict, and therefore he has challenged it. Let's introduce our panel of experts today as we try and understand this battle. Joining us on the program is Sanjay Hegde. Sanjay Hegde is a senior advocate, and it's good to see him after a long time, Sanjay. Also joining us is Abha Singh, well-known senior advocate and rights activist. Also joining us on the program from Gujarat today is Asim Pandya. He's a senior advocate, but he has a very interesting story. He wanted, in fact, to challenge why he was not made a judge, tried to take that case to the courts and, of course, drew a blank. But then the judge who delivered a verdict on him himself became a victim, as he says, of the collegium system. So very interesting there. Also joining us from the BJP is its spokesperson and leader, Mukesh Tyagi. Good to see you, Mukesh. And also finally joining us is Justice Ganguly, who of course has been on the Supreme Court bench. It's good to see all of you. Let me start by actually framing the debate with the help of the Vice President himself. The Vice President takes us back to the 2015 moment when a unanimous decision by Parliament is struck down by the Supreme Court. He's talking, of course, about judicial appointments and the legislation that was brought in to give the government a say in how judges are appointed in. This is what the Vice President said on the NJAC. Listen in.
यदि अगर संसद के बनाए हुए कानून को किसी भी आधार पर कोई भी संस्था अमान्य करती है तो ठीक नहीं होगा प्रजातंत्र के लिए, बल्कि कहना मुश्किल होगा आर वी अ डेमोक्रेटिक नेशन। 2015 16 अक्टूबर का दिन लोकसभा और राज्यसभा ने एक कानून पारित किया जिसको आम भाषा में हम नेशनल जुडिशियल अकाउंटेबिलिटी कमीशन का कानून कहते हैं। लोकसभा में सर्वसम्मति से वो कानून पारित हुआ, सर्वसम्मति से। राज्यसभा में भी सर्वसम्मति से पारित हुआ, पर एक अब्सटेंशन था, लोकसभा में कोई अब्सटेंशन नहीं था। संविधान की आवश्यकता थी कि मोर देन 50% लेजिस्लेचर पास करें। राजस्थान लेजिस्लेचर वाज द फर्स्ट वन इन द कंट्री टू रेटिफाई इट। ऐसे कानून को 16 अक्टूबर 2015 को 4:1 में सर्वोच्च न्यायालय ने निरस्त कर दिया। दिस इज नॉट अ चैलेंज टू जुडिशरी, दिस इज बिलीविंग इन द कॉन्स्टिट्यूशन, दिस इज बिलीविंग इन डेमोक्रेसी। दुनिया में ऐसा कहीं नहीं हुआ है।
Okay, I think it's appropriate if I start with Justice Ganguly. Justice Ganguly, what do you make of this debate? Two things have happened here. Repeatedly, the Vice President, no less, is questioning the fact that the Supreme Court read down a law made by Parliament unanimously, with the exception of one member of Parliament, if I'm not wrong, was Ram Jethmalani. Justice Ganguly, let me start with you.
Yes, this is not the first time that the Supreme Court is striking down a law unanimously passed by the legislature, by both the houses. This Supreme Court has this inherent power. If what Mr. Dhankar is saying with respect to him is correct, then Article 13 of the Constitution will lose all its force. Article 13 says, which is part of our fundamental right, that the state shall not make any law if it infringes or takes away our rights under Part 3, that is fundamental right. And if any law does it, then the law, to the extent of its inconsistency with Part 3, will be rendered void. And who can law render void? It can only be done by the judiciary, no other body. And in exercise of this power of judicial review, Supreme Court has in the past outlawed many laws just because it is passed by Parliament. There is no sanction that Supreme Court cannot examine it. Then, then Supreme Court's power under Article 19 becomes redundant. Where under Article 19 there is a doctrine of reasonable restriction. Our fundamental rights are subject to reasonable restriction by law. Suppose a law restricts our fundamental rights, say freedom of speech, says that you cannot exercise your freedom of speech, say, except 12 o'clock at noon. Beyond that, you cannot exercise. If there is such a law and the Supreme Court strikes it down, it is striking down many
So you
laws.
don't agree? So you don't agree with the Vice
Then who can
President?
do it? Only no, certainly not. It's a complete misconception of constitutional fundamentals. With great respect to the office which is holding, Mr. Dhankar, I am saying so. This is not the first time Supreme Court is doing it. These are ingrained, inherent in our constitution. And look at Article 245, which gives
Hmm.
the power to the parliament to legislate. It starts with the words, subject to the provisions of the constitution, the parliament can legislate. The parliament is not supreme. What is supreme under the constitution is the constitution. Parliament is set up under Article 79 of the constitution. You look at
Yes.
79, there shall be a parliament. And all the nitty-gritties of parliamentary formation are controlled and delineated by the constitution. It's a body under the constitution. That is the
So
problem. That's the clear reading of the constitution.
now, Justice Ganguly, what I'm going to do is actually play out. The Vice President didn't just question the Supreme Court's power to change legislation that has been cleared by Parliament. He questioned the basic doctrine principle, which has become the precedent ever since 1973 in the famous Keshwan and Bharti case. Before I open this up for the panel, do listen to what the Vice President had to say.
In democratic society, basic of any basic structure, जिस बेसिक स्ट्रक्चर के बारे में बताऊंगा जो आपका विषय है, बेसिक ऑफ एनी बेसिक स्ट्रक्चर इज सुप्रीमेसी ऑफ द पीपल, सोवरेंटी ऑफ द पीपल, सोवरेंटी ऑफ द पार्लियामेंट. क्या पार्लियामेंट का पावर टू अमेंड द कॉन्स्टिट्यूशन किसी और संस्था पर डिपेंड कर सकता है? क्या भारत के संविधान में कोई नया थिएटर है जो कहेगा कि पार्लियामेंट ने जो कानून बनाया उस पर हमारी मोहर लगेगी तभी कानून होगा? 1973 के अंदर एक बहुत गलत परंपरा चालू हुई. 1973 में केशवानंद भारती के केस में सुप्रीम कोर्ट ने बेसिक स्ट्रक्चर का आइडिया किया कि पार्लियामेंट कॉन्स्टिट्यूशन अमेंड कर सकती है पर बेसिक स्ट्रक्चर को नहीं. विद ड्यू रेस्पेक्ट टू द जुडिशियरी, आई कैन नॉट सब्सक्राइब टू दिस.
Now, these remarks could have been ignored had they come from even a BJP minister. But when they come from the Vice President, can they be treated, Sanjay Hegde, as non-serious, as simply saber-rattling? How do you see these remarks, Mr. Hegde?
Well, these remarks are part of a pattern. Long ago, in one of the James Bond films, it was said, the first time can be happenstance, the second time can be coincidence, but the third time is generally enemy action. And this continual line of attack against the judiciary, and going after the basic structure is something which is unthinkable in the old BJP at least. The basic structure doctrine came about at a time when the constitution was similarly under stress from an overpowering executive. The judiciary had earlier said that no, you cannot amend the fundamental rights at all. And that was Golaknath. After that, then came Keshavananda, where they said, no, you have you can amend the constitution, but you cannot amend it in a manner that you damage its basic structure and the basic features. And what are those basic features? There have been various instances given. I've said on other forums that two things happened in April 1973, which kept India together. One was the Supreme Court judgment on the basic structure. The other thing was the birth of Sachin Tendulkar. These were two things which sort of joined India in a common stream.
I dare not ask which one you give greater primacy to. I'm worried about your answer, Sanjay.
No. Yeah, you should ask Justice Ganguly. He's also a great cricket enthusiast.
Cricket fan.
But the thing is that why is the BJP and why are its constitutional functionaries going after the judiciary over the past few months? I half also suspect that Nehru is no more a fashionable whipping horse, or they've done with Nehru. They need a new straw man to fight against.
Okay, let me bring in Mukesh Tyagi at this point of the BJP. Mr. Rijiju, the law minister, said the government has no intention of bringing in a new law on how judges are appointed. If that is indeed the case, how do we understand the vice president's repeated attacks on the courts and an attempt to, in a way, limit their authority and their powers, Mukeshji?
Barkha, good evening. I think Vice President is entitled to give his opinion. He's also a lawyer by profession, and it has got nothing to do with BJP, but this debate has been going on for quite some time. As a matter of fact, I think the intervention in the judiciary began very heavily by Mrs. Gandhi. And when the supersession of judges happened, Justice A.N. Ray was appointed over 3 judges. And there was a supersession of judges, there was a transfer of judges. I think the Congress had completely mutilated the judicial system in India. Now, the point is, the basic premises were the collegium system. I mean, whatever you may say, maybe Keshwanand Bharti case came in 1993 when the basic structure cannot be altered. Was the basic 73. Sorry, I stand amended. 93, the first judge's case happened actually. So. Yes. And then 73 Keshwanand Bharti happened after Golaknath case. So the basic structure cannot be altered like fundamental rights and other things. But you see, the basic premises, do you believe in a status quo? Number one. Number two, there is no constitutional provision which supports this institution of a collegium. So like 2015, when the judgment was altered of the NJAC by the Supreme Court on the pretext, now I'm using a wrong word pretext, but under the shelter of the Keshwanand Bharti, I think they did not allow any innovation to happen in the judicial appointments. So I think why judiciary? First of all, judges cannot appoint judges. That is fundamental conflict of interest, because you are dealing with the fellow judges all the time. I mean, somebody was making a statement. I don't know how far I must give the adherence, but there are only 70 families in the country who decide who will be the judges in the Supreme Court and High Court. So there has been, when some kind of controversy begins, I think judiciary has to come above board. They said, we will welcome the best institution which will appoint the judges, and we want the meritorious judges. As a matter of fact, it's not only independence of judiciary, it is also independence of competence of the judges. Now, whether
but it's a matter. Mukeshji, you say that the vice president's remarks are his own remarks. They're not the BJP's remarks. But may I remind you, with great respect, that the law minister had spoken about how judges, instead of delivering justice, are more busy thinking about who should be judge. The law minister had also questioned the collegium system. So people will draw the dots between the vice president and the law minister's remarks, won't they?
Okay, that is a conjecture. I mean, we are not prompting Vice President to make such a statement. I think he sees the merit in the conversation, and he being the custodian of Constitution, implementing the Constitution. So I think he's entitled to his views. But I'm talking as an independent, not even endorsing what our law minister has said. Law minister has raised a very relevant point, and I think the judicial appointment needs to be reviewed. As a matter of fact, whether are we getting the judges, is there a
Okay, hang
possibility,
on.
yeah.
Yeah, hang on. We've got the gist of your argument. Let me take it to Mr. Asim Pandya. Mr. Pandya, you're not a hang on one second, let me just get in Mr. Pandya here. Mr. Pandya, you're not a fan of the constitution of the collegium system. Tell us a little bit about your own experience. Not everyone on the panel may be familiar with it. You were in line to be a judge. You were not made a judge. You took your fight legal. You got
Right.
no answers. Can you tell us just a little bit about yourself?
Actually, my name was recommended in 2009 for High Court judgeship, but somehow because of political interference, it was not through finally. Then after deliberation with myself, after 6 months reading of all those judgment, SP Gupta and Supreme Court AOR judgment, and then presidential reference judgment, my basic contention was that there has to be at least a principle of natural justice to be followed when somebody is excluded or eliminated from the zone of consideration. So he is supposed to know the reasons. I am not provided with the reasons. So that was the fundamental issue. I did not want appointment itself because unless I made myself clear that basic things which I wanted this, that there has to be intimation, at least courtesy demands that somebody is invited to become a judge. And when I came to know that somebody is appointed and I am not being appointed, so that was the first issue. And presidential reference judgment also provides that if adverse material lies against any candidate, he can be given an opportunity to explain it. So that was also
So,
not
so,
being
so,
done.
so you got no answers, and then I think you
So
told me that the judge who gave your judgment was also in line to be to get a
yes,
promotion, and then did not.
he did not
Yeah.
get it. Yes,
So
yes.
what goes around comes around. So are you a fan of the collegium system or no, Mr. Pandya?
No, basically, I have recently written one article suggesting certain amendments in the collegium system because now NGA has been struck down. So we will have to accept that
Yeah.
situation. We cannot keep on debating this and criticizing that aspect anymore. One has to go with
Right.
it,
Okay.
and now we will have to find out ways. What are the amendments which can be suggested? So I have
Ways to
written a
reform.
detailed
Yeah.
article.
Let me bring in Abha at this. Let me bring in Abha at this point. Abha, how do you see the Vice President's remarks? Abha.
Barkha, coming on the heels of the law minister, when Vice President also attacks the judiciary and the method of appointment, I think it is a concentrated attack of the government so that judicial supremacy should be undermined. Because if you see right now, we don't till the time a new CJI takes over, everybody's on tenterhooks. Whether he will become or not become, whether he'll become, who will become. Why don't we have a set thing that on this date, this person is due, he will get it. So you need to make these things. And of late, giving these CJIs, member of parliament, or giving them other NGT chairmanship, I think that way they're trying to lure the judges. We really need accountability. We need transparency. And the government has to be separated. When the constitution is very clear that there has to be a separation of powers, I stand with the basic features. Because at one time when we talked, somebody talked of 42nd Amendment. You try to say the directive principles are above fundamental rights. Why does the government have problem with the fundamental rights? Be it Congress, be it BJP, let it be very clear. Let us go by the constitution. Let us go by the law of the land. Nobody should be allowed to tamper with fundamental rights. Nobody should be allowed to tamper with their freedom, and that is what should be the basic of everything. Yes,
you see this as a political attack. You see this as clearly political, Abha.
Every time, every government, whoever is there, they don't want a strong judiciary, independent judiciary, because then it is a proper, pure democracy where the citizen is ultimate. So that is what I feel, that every time you're trying to either undermine the judges or undermine the law of the land. We need to have the separation of powers in the true sense, like when they said that judiciary, when it struck down in the Minerva Mills, it struck down section 5 and 55 saying that no directive principles cannot supersede fundamental rights. So my interest as a citizen, as an activist lawyer, is that our fundamental freedoms have to be protected at any cost.
Okay. Okay, before I go back to Justice Ganguly, I want to go to Sanjay Hegde briefly. 2 points, 3 points have been raised by, in a sense, skeptics of the collegium system. Asim Pandya's own example, where he said, at least I had a right to know why I was overlooked, the opacity of the collegium system. Mukesh Tyagi saying, whether or not you agree with how far Jagdeep Dhankhar has gone in this argument, the status quo, not all judges are fans of the collegium system either. And the fact that in a way, the collegium showed its own cracks, at least before Justice Chandrachud became Chief Justice, and when Uday Lalit was still Chief Justice, there was such an open sort of rupture that the Supreme Court had to take the unprecedented step of issuing a press release. So, Sanjay, do you first acknowledge that there are problems with the present system?
Of course, there are problems. But you must also remember, why did the collegium system come about in the first place? It was a time when Ram Jethmalani famously said, there are two kinds of judges, those who know the law and those who know the law minister. And as a consequence, it was felt that, when they consult the judiciary, the consultation should be broad-based. The senior-most judges should all weigh in. And if at the end of that consultation names emerge, they are recommended to the government. The government should normally appoint them. But if the government has some misgivings, put those misgivings down in writing, send it back to the collegium. And if the collegium, having seen those misgivings, says, no, please, this person has to be appointed, the government was bound by it. This was the system. Yes, collegiums, there are ruptures, but ruptures are also healed. And there is one great virtue about the collegium, which is also its weakness, is that the collegium is never a permanent body. People come, people go, the composition changes endlessly. So very often, five plus three people, 3 people at the High Court stage, five at the Supreme Court stage, are more likely to come to, on an average, a better decision than a single law minister or a single political party running it from in Bengal. I forget where the communists ran the party apparatus at that particular point. Or you run it from Nagpur.
But are you saying then that the collegium is like democracy, with all its flaws, it's still the best system we have? Is that what you're saying, Sanjay?
I am saying that with its flaws, it can be better. Maybe it can take inputs from more people. Maybe it can have a permanent secretariat. Maybe its decisions could be more open. And as far as Asim Bhai's case is concerned, Asim Bhai may want to know the reasons. But if reasons are given to Asim Bhai in writing, that remains on the file somewhere. And that may not be acceptable to all people in the same position.
Yeah, that's a good.
So that is why often people are, there's nothing kept in writing.
That's a good point, and I'll take that back to Asim Bhai. But Justice Ganguly, you've expressed some skepticism also about how the collegium system works. Would you want a new system, or would you say this system needs to be reformed? Because at the heart of the vice president's sort of criticisms of the judiciary, that is what it's about, how judges are appointed.
You see, the collegium system, I admit that there are certain flaws. There are cases of nepotism. I admit that. But even then, this is the best system available. Now, look at our history, what has happened. Judges like Justice Khanna, Justice Hegde, Justice Grover, Justice Fellat, they were superseded not because of their lack of ability, but just because they expressed opinions to their judgment which are not to the liking of the party in power. At that time, it was Congress party. You see, They were just because my views are not welcome to the government in power, I will be denied. This was really actually said by Justice Khanna when he signed the dissent in that habeas corpus case. In his autobiography, he has written, he came back while having tea with his wife and his sister. He said, possibly I passed an order which will cost my chief justiceship, and it did. He was superseded. A judge of his caliber was superseded because the government had the primacy. That has to be remedied. Judicial independence has to be restored. So, for restoration of judicial independence, this collegium system is the best system available, because the judges would know the basic intrinsic quality of another judge.
But how do you respond to Asim
Uh,
Pandya's how do you respond to Asim Pandya's questioning
this,
the
this,
courts,
this,
saying,
there
"Tell me
are,
why I didn't become a
I've
judge"?
told you, there are unfortunate cases. In
Yes.
Calcutta High Court, this has happened. An eminent judge like Justice Bhaskar Bhattacharya was not taken to Supreme Court. There are instances. Everybody resents it. But even then, I think this is the best system available. If we
Let
allow the power crazy executive to make the choices, it will create disaster
Yeah.
in
So
the
let me get
judicial
in.
administration.
Mukesh, Tyagi, I think everybody conceives there are problems with the collegium system, including judges themselves. But the alternative is to give politicians a say in this, which can't be healthy, surely. It doesn't matter. Today it's your government, tomorrow it'll be some other government. And that is why there was the kind of unanimity that we saw when it came to the judicial appointments legislation, sir, in 2014, later struck down in 2015, because no politician, every politician would want to control how judges are appointed, Mukesh.
Barkha, I think Lord Acton said that power corrupts and absolute power corrupts absolutely. Now, the constitution is based on the separation of power. Now, there is another hypothesis called checks and balance. Now, if the 100% power is given, there is no checks and balance. I think we will not do great service to the constitution, and constitution needs to be protected from any tyranny, from any undue authority or power which can alter the entire future of the country. As a matter of fact, Supreme Court is not a, I mean, every word matters in shaping up the destiny of the country. I think there has to be, look at the way, Barkha, I'm not critical that there is anything going wrong, but I think the fundamental premises of collegial system is so flawed. I mean, we appoint even Munsif by taking a very strenuous examination, and there is an independent authority. Judges are already overburdened. Why do you intend to give them additional administrative responsibilities? 50, 60 cases are being disposed of by the Supreme Court judges every day, and then again they have to apply their mind and go through this, politics within the fellow judges, that whom should be appointed, who should not. It's a close fraternity. So there are influences and cross currents happening at this time. So I think it's a high time, Barkha, to invent a new system which gives independence, which takes away this opaqueness. Like one of the fellow panelists is raising the issue that he was not giving the speaking order, and court believes in a natural justice. So if they are themselves contributing to the violation of natural justice, you are not aware what are the grounds of appointment. So I think there is a completely non-transparency, and I think as a citizen, I'm entitled to know how the judges are appointed. People should
Okay.
know the constitution is for the people,
Okay.
not by this. I'm sorry to say that collegium system is completely like a black hole. You have no idea what's going on inside.
Asim Pandya, is that something you would agree with, having been at the receiving end of it, that the collegium is like a black hole? And again, Justice Ganguly and Sanjay, Hegde and Abha Singh are saying, what's the alternative?
My suggestion is that it should be, the decisions of the collegium should be subject to judicial review, because as per the all three judgments, the eligibility is subject to judicial review, but suitability is not subject to judicial review. Now, if you examine the aspects of suitability, most can be tested on objective material. So if it is permitted, the decision which has been taken by the collegium, which is right now not subject to judicial review, which is a basic structure. Now you are taking away basic structure, and you are not permitting this decision to be reviewed by their peers. We are not seeking review from any advocate. It is by themselves. They have to judicially examine the decision. So my suggestion is that first person should be given reasons if he wants. I am not in favor of disclosing on the notice board of the Supreme Court, but if person demands the reason, it should be made available. and there has to be principle of natural justice to be followed. If adverse material is to be used against him,
So you, yeah,
judicial review, full judicial review. It cannot be a truncated
that's a
judicial
specific.
review.
So that is a specific argument we have here, and I want Abha and Sanjay's reactions to it. Collegium decisions must be subject to judicial review is a concrete sort of argument being made by Asim Pandya. Abha, do you agree?
Barkha, I feel some change, some tweaking can be done to the system because, as rightly said by my co-panelist, that judicial review to these appointments, a person whose name is dropped out of this blue should get to know the reasons why it has happened. But the NJC had so many flaws. The two eminent persons, who were they going to be? You will have the law secretary who is we know how bureaucrats are working. They are stooges of the government, and in fact now you have information commissioners, or in fact courts have come out and said that only retired IAS officers and bureaucrats are getting all these important postings. So you get again in NJC, you appoint two eminent persons who have been in the IAS or a law secretary, then you jeopardize the independence of the judiciary. But if you come to collegium, yes, of course, a little transparency can be brought in, but main thing is collegium is the only thing that will maintain independence of the judiciary, not the NJC.
I think the consensus that is sort of emerging once again is that the collegium system can be reformed, but it can't be done away with, except for Mr. Tyagi and clearly Mr. Dhankar, who have a very different view. Let me get last comments from Sanjay and Justice Ganguly. Sanjay, to you, since you also agree it needs reform. Mr. Pandya's suggestion, Asim Bhai's suggestion is subject it to judicial review. But Asim tried that and he got opacity even in that process.
Yes, see, judicial review in the case of a non-appointment like Asim Bhai? Maybe. But can you have judicial review in the case of an appointment? Why was such and such a person appointed? He was a wife beater, he did this, he did that, all that thing, then you're asking for much more trouble. I don't think that is
but why?
an entirely
But Sanjay,
good...
Sanjay, we would raise those questions. I'm saying, if you look at the American system, for example, when Mr. Kavanaugh was elevated to the Supreme Court, there were all kinds of questions about, for example, his treatment of women, and he went through a fierce public scrutiny process before his elevation was endorsed. I think the point everybody is making is that the questions we subject others in public life to. Judges are not above that scrutiny. They cannot be above that scrutiny.
They're certainly not above that scrutiny. And the collegium is ultimately a form of peer review. Judges, just because they happen to have gone on the other side, don't cease to be men and women of law.
I think Asim Bhai is trying to say something to you briefly, and then I'll let you complete your point.
When we are seeking judicial review and candidate, his name is omitted, he is seeking his enforcement of his own rights. Whereas if you are questioning the appointment, then it would be seeking writ of quo warranto. So then it would not be subject to judicial review, because quo warranto would be affecting only when there is lack of eligibility. So when appointment is there, it cannot be subject to judicial review. But when it is non-appointment, it affects the individual rights.
I understand. You're saying that person's rights
at the instance of that person. Yes.
Got it. Sanjay.
Yes.
Sanjay.
Okay.
Yeah.
Okay. Let me. I've more or less said what I wanted to, but I just want to give your viewers one more example. Yeah. Again, it's a cricketing metaphor.
Okay.
Would you have a selection of the cricket team done by people who have played cricket, or would you leave it to Jai Shah and Anurag Thakur?
Or Rajiv Shukla? It's not just one party that wants to control sports.
Okay, or Rajiv Shukla, yes.
Yeah, okay. That's the point. Politicians want to control everything from cricket to courts. We have to also acknowledge that as being on the other side, as it were. There has to be some middle ground here that makes the system accountable. So status quo can be challenged, but I don't think anyone's convinced that politicians on that bench are the answer. Justice Ganguly, last word to you, sir.
First of all, let me make it very clear. Nobody has a right to be appointed a judge. Nobody has a right. It's a question of selection. As it has been said, it's a post to which so many are called, but so few are chosen. We have to accept that. Many eminent lawyers have not become judges. That is neither here nor there. And the question of review, there is a kind of peer review, as Sanjay has said. We will just remember what happened recently when Chief Justice Lalit circulated 5 names among the collegium members, but they returned the file saying that there has not been proper consultation. So when 5 judges are discussing among themselves, I know as a matter of fact, the consultation is intense and very serious consultation.
But Justice
That's a
Ganguly, no,
kind of review.
sorry, I'm sorry,
This
I'm
has
interrupting
happened very
you.
recently.
But peer review can also be a euphemism for a clubby sort of
No,
insiders
not
club.
necessarily. Not necessarily. These 5 judges coming from 5 different regions. It
Yeah.
is not a club. It is not a club. Therefore, the decision, the review, what they do within themselves is an objective consideration of the merits of the case. And now I can understand that the judgments of the judges are also looked into, were
Okay.
taken to Supreme Court. Therefore, there is a proper review. And as Sanjay said, review by whom? By no persons who know the matter more best. The judges
Well,
are appreciating the quality of another judge to be taken to Supreme Court.
Well, we'll have to leave it
The,
there, but I will say, sir, with respect, that I think that many people would want to see some change, more transparency in the status quo. But with respect to the
yes.
BJP spokesperson, Mr. Tyagi, I would also say that that change. It doesn't matter which party, sir, yours, Congress, somebody else. I think most people would want a different system, never to give politicians too much power. That is how powers are divided in our
Can I
constitution.
add one? Can I
Yes,
add one sentence?
sure, sure.
I tell you, I was a judge for some time, had some experience. Every party, every political party wants pliant judges. No political party in India, none of them would want strong judiciary.
That's
Take
right.
it from me. Take it from
That's
me.
right. That
Whether
is
it
the
is
bottom line.
Congress,
Yes.
whether it is BJP, whether it is communists, all of them want supple and pliant judges. When they
And I
don't
think,
get them, they raise a hue and cry. They listen hue and cries like that.
well, that is the
You
bottom
see,
line. Every political, yeah.
a sedition has been suspended by Supreme Court, much to the dislike of the government, but for very good reasons.
Yeah. Well, there are a lot of things. The flip side, of course, if I may say in my concluding remarks, is sometimes the government doesn't want to take the risk of a decision and it leaves it to the court. It could be the decriminalizing of homosexuality. Now, same sex marriage has gone the legal route. There's so many cases, the Vishaka guidelines, all of these have come from the courts, whereas they should have come through the legislative process. So I think the bottom line is no political party wants an independent judge. But at the same time, the bottom line also is that the collegium system has been questioned for its opacity and also for its lack of diversity. So I think those are also questions that the lordships may want to consider. For the moment, Mukesh, Tyagi, Justice Ganguly, Sanjay, Hegde, Asim, Pandya, and Abha. Thank you so much, Abha Singh, and to our audience. See you tomorrow. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.